It is officially 2026, and I know you're probably thinking new year, new me, but when it comes to US immigration, 2025 is surely following us into 2026. So let's talk about all the updates and changes that happened in 2025 that will unfortunately be following us into 2026. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The biggest change that will be flowing us into 2026 is, of course, the travel bans and the USCIS interpretation of those travel bans. I did a whole video on the travel bans, so make sure to watch that video. But I want to let you know that the 19 countries that were on the list as of June of 2025 are still technically on the list except for one country. And then additional countries have been added to the full travel ban list and the partial travel ban list. Basically, the difference between the full and the partial is that the full travel ban applies to immigrant visas and non-immigrant visas, whereas the partial travel ban really just applies to non-immigrant visas, meaning temporary visas to the US. If you are from one of the countries on the travel ban list and you have an application pending with USCIS, just know that the initial 19 countries from the June travel ban, USCIS is not going to make decisions on their cases until further notice. Now, people added newly to the travel ban will probably see in 2026 that USCIS will update their procedure to add those newly added countries to that pause as well. So that is what I'm expecting to happen with that travel ban list. We have seen that one of the countries were taken off the travel ban list. So there is hope that if these countries meet USCIS requirements, whatever they may be, that they will be taken off the travel ban list as well. So hopefully your country gets taken off the travel ban list in 2026. Another major change that's following us into 2026 is, of course, the NTA memo that went out to USCIS. USCIS basically issued an NTA memo basically saying if you have an application pending and you're also removable or deportable, USCIS can and should put you in deportation proceedings. Yeah. So before, if you had an I-130 pending, even if you are deportable or removable, USCIS typically would not put you in deportation proceedings. However, with this new memo, even if you have an application pending with USCIS, if they see that you are deportable, they can and are encouraged to issue that notice to appear for immigration court. What does this mean practically in 2026? It means that before you file any application with USCIS, you really need to make sure, one, that you qualify for it and you understand the risk of filing the application. Because even if you have a US citizen spouse, if you entered without inspection, you will not be able to adjust your status in the US, and USCIS can use that as a way to put you in deportation proceedings. So you really need to think through before you file any applications and make sure that you understand what you're filing, why you're filing it, and the potential risks involved. And of course, the potential benefits as well. So if you have a US citizen spouse, you entered with a visa, your marriage is real. The worst case scenario in most situations is that you may end up in deportation proceedings and be able to apply for adjustment of status in immigration court. Okay, that's again, if you do qualify for it, you would be able to apply for it in immigration court, but no one wants to be in immigration court. I know. But that's part of the risk assessment to know if it's something that you can overcome if you are potentially put in deportation proceedings. Next thing is for my DV lottery people that are waiting for the lottery to open to enter their application. Well, that has been suspended until further notice. Typically by October every single year before 2025, the U.S. Department of State will release the DV lottery entry system. People can put in their information and hope to win a lottery and then apply for a visa to the U.S. Right? That has been the system for a very, very long time. Well, in 2025, that system got upended because the US government decided, one, that they're going to change the requirements to not require you to upload your passport as part of the application process. And then after that, they also decided that they wanted to put in a $1 fee for entering the lottery. Again, all of that is fine. But then in December, they decided to just end the whole process and not even put out the lottery for the year or until further notice. So if you were hoping to enter the lottery, just know we don't know if it's going to come back, when it's going to come back, or what the rules are going to look like if it does come back. I will update you because if you do not already know, I love the DV lottery because that is the only reason I am in the US. My dad actually won the lottery, came to the US, and then years later filed for us to come to the US to join him. So when I say I love the DV lottery, I love it. It has a very special place to me. So I'm hopeful that it will come back. But with the way this administration is moving, I don't really see it coming back anytime soon. But fingers crossed that it does. Another update to the USCIS policies that will be following us into 2026 is, of course, about naturalization. When you want to apply for citizenship, you are now going to have a harder test. So it went from studying 100 questions to studying 128 questions and having to get 10 out of 20 correct, from having to only get 6 out of 12 correct. So when it comes to the citizenship test, just know it's going to be more rigorous, and the background check and the questions that's going to happen as part of that citizenship process is also going to be more rigorous. It's going to have a more rigorous standard for good moral character moving forward. Before this new standard, you typically just have to show that you're paying your taxes. If you have children, you're taking care of your children, and that you do not have any criminal history that affects your good moral character. Well, moving forward, not only do you have to prove all those things, you also have to prove that you are a good member of your community. And USCIS can do community inquiries, meaning they could literally talk to your employer, talk to your neighbors, and see if the things that you are doing in the community is good, right? Is indicative of a good moral character. An example of where this rigorous standard really is going to affect people is that it's really up to the officer to determine if whatever that activity is that you are engaged in, or they're saying that you're engaged in, if it is against community standards. Now, where the standards are coming from, whose standards they're using, we do not know. But is it against community standards? A simple example of this is if you get a lot of parking tickets, right, or speeding tickets, you may have to now explain why you're getting those parking tickets, and also provide additional evidence from community members and all of that, showing that you are a person of good moral character. You just happen to park in bad places sometimes and get those parking tickets, or park for too long and get parking tickets, right? So just know, when it comes to now the naturalization process, you're going to have a harder time, but you, if you qualify, can still be approved. So that's really the key here. Even though all of these things are being stacked against you, just know, if you meet the requirements, if you meet the standards, you can be approved. Now, remember I said that the 19 countries that were on the original travel ban list, USCIS is pausing their applications. Well, that also applies to naturalization. They are also pausing those applications. But they're also saying that once they unpause it and review your case, your country of origin, if you're from one of those 19 countries, can be used as a factor in that good moral character in that equation. But they're also saying that once they unpause that and the officers start looking at your application, your country of origin, if you're from one of those 19 countries, can actually be seen as a negative factor when an officer is making a determination based on all the facts and circumstances. If it is up to the officer's discretion, they can use your country of origin as a negative factor in that determination of discretion. I hope you are getting value out of this video so far. If you are, please hit that like button. Tell me in the comments what is one USCIS update that you are most concerned about or that you want me to cover in more detail in a future video. In the age of social media, this next one is really important. The US government is going to use your social media presence, your social media statements as a negative factor in your case. They are going to review your social media accounts. We have seen them deny visas, refuse people entry into the US solely based on their social media activity. So I see this moving forward being more important. Right now, we're seeing it mostly in people applying for visas to the US or entry into the US. But I do foresee this playing a bigger role in USCIS, FDNS investigations. So FDNS is their fraud investigation unit. So when they're doing those investigations, I foresee social media being a huge part of that process. So be aware of what you're posting on social media because it can negatively affect your case, especially if it's just your speech, right? So just be careful of that. I'm not telling you to limit your speech, but understand the risks involved. Unfortunately, that's what we're going to be doing a lot of in 2026 is managing the risk. There's risk in every single thing you're going to do when it comes to US immigration. So you want to make sure that you're taking steps to minimize those risks. One of the things that is going to be following us into 2026 is USCIS has new fees. Immigration court has new fees thanks to OB3. So the one big beautiful bill, right? Thanks to that, there's new fees involved with certain applications and there's no fee waivers. So not only are there new fees, increased fees, and in some situations like $1,500 more, and there's no fee waivers. So we're going to see people struggle more to make those things happen. So we're going to see people struggle to pay those fees just because of how much more they cost from a year ago. And the final thing I want to cover is the change that USCIS has made to the CSPA calculations. Before this change, USCIS based their CSPA calculations to determine if the child is over 21, under 21, can still be a derivative of their parent, or can still be considered an immediate relative. Those calculations were based on the filing date and not the final action date for USCIS. Remember, the embassy is completely different. The Department of State, the embassy, based theirs on the final action date, whereas USCIS was basing theirs on the filing date. And the filing date is better. Basing it on the filing date is better for the applicant than basing it on the final action date. So what we're seeing is USCIS basically going back to their old procedure of basing the CSPA calculations on the final action date, which is going to cause a lot of people to age out and not be able to continue being a derivative under their parents' application. So this is a big deal. If you're wondering if you are aged out based on the new CSPA calculations for USCIS, remember, it's different from the embassy. If you're in the US and trying to do that through USCIS, you want to look at the CSPA rules for USCIS. So if you want to know how to calculate it and all of that, I did a whole video on my channel where I talk about CSPA and what the new calculation is and gave you specific examples so that you can plug in your own information and see where you land when it comes to that CSPA calculation. 2026 is going to be rough for a lot of people in the immigration community, but just know there is help. There are people that are willing to assist you, and because of that, I am still going to continue doing my free 15-minute strategy sessions and offering that out there for anyone that needs it, because there's so much going on in US immigration that sometimes just having your question answered will make just a world of difference and give you direction. So I'm still going to be offering that 15-minute free strategy session. If you want a more in-depth consultation, I do offer that as well. It will be a detailed consultation, and you can also book that on my website. If you would like to schedule a free strategy session or a detailed consultation, you can do both of those on my website. You can go to lilylegal.com, click on contact us, and you can pick a date and time that works best for you for us to discuss your situation and see if we can get you on a path to a green card, citizenship, something that you're looking forward to as far as your immigration goals in 2026.